but there are a bunch of folks here, so welcome. So good evening, everybody. Welcome. I recognize a lot of names, and so I recognize that a lot of you are probably similarly situated in terms of being very exhausted from lots of shoveling and digging ourselves out today. So we're really thrilled that you could be here. I think this is a wonderful way to get together on a cold day. So thanks for joining us. And I'm sorry we couldn't be in person, but it's still wonderful to see folks in this way and to be able to get together virtually. So tonight, it's my real pleasure to introduce our speaker, my colleague, but also my dear friend, Ray Brescia. So Ray serves as our Associate Dean for Research and Intellectual Life, and he also holds the Honorable Harold R. Tyler Chair in Law and Technology. Now, many of you know Ray very well, but his academic journey began at Fordham University, where he earned a degree in political philosophy, a degree that I would say Ray has and continually puts to good use. And then after receiving his JD from Yale Law School, he really dedicated himself to public service. So first as a Skadden Fellow at the Legal Aid Society of New York, and later as an Associate Director at the Urban Justice Center. He joined the Albany Law faculty, lucky us, in 2007, and has distinguished himself as one of our most prolific and impactful scholars, but also as a great shepherd and supporter for scholarly work and thinking at the law school more broadly, for which I'm very grateful. Ray's scholarship spans a remarkable breadth of topics, from the role of social movements and driving legal change to legal ethics, technology, and access to justice, all of which, of course, are pressing topics for us today. Now, with over 60 academic articles published in leading law journals, including recent contributions to the Ohio State Law Journal, the Georgetown Journal of Legal Ethics, the Fordham Law Review, and the Penn State Law Review, Ray's work is highly regarded in the field. He's also the author of 3 previous books, including The Private is Political, Identity and Democracy in the Age of Surveillance Capitalism, which we celebrated last winter. Many of you may have joined us. Lawyer Nation, The Past, Present, and Future of the American Legal Profession, and The Future of Change, How Technology Shapes Social Revolutions. He's also the editor of several other books, including Crisis Lawyering, Effective Legal Advocacy in Emergency Situation, which continues to be highly relevant 5 years after publication. Ray is an internationally recognized legal scholar and public intellectual whose insights have been featured increasingly so, I would say, just many times this year on CNN and in op-eds for the Washington Post, The Hill, the LA Times, Slate, and the Daily Beast. And he's regularly quoted in major news outlets worldwide, including BBC, Newsweek, and ABC News. You can also find him as a regular contributor to Legal AF podcast, where he discusses the critical legal issues impacting our world today. Tonight, we're all very lucky because Ray is going to be discussing his 4th book, Lawyer 3.0, A Guide to Next Wave Lawyering. This is published by Bristol University Press, was published by Bristol University Press late last year. Now, in Lawyer 3.0, Ray takes on a subject that is on the mind of just about every lawyer and every law student. I get questions about it all the time. How will emerging technologies, particularly artificial intelligence, change the practice of lawyering and our economy as a whole? Now, as he often does, Ray uses his great depth of knowledge of history to illustrate how technology has transformed our profession in the past and how those transformations give us a window into how lawyering is likely to function in an AI-infused world, the world we're all living in. He argues that new technologies have the potential to increase access to legal services, and then does what he does best, which is he offers a roadmap. I love that about his work. So he offers a roadmap for how lawyers can adapt and thrive in what will likely be a pretty dramatically different landscape than the one we now know. Now, this work is just an example of the ways in which Albany Law School, more broadly, is continuing to lead as we enter in a new era in the legal profession, what, as Ray's title suggests, is Lawyering 3.0. Now, along with this work that you'll hear more about tonight, Albany Law is offering courses related to AI and the law taught by Professors Akala Laboy and Professor Rosenblum, and our wonderful adjunct professor Colin Levy. We lead in the area of cybersecurity through Professor Anthony Haynes' work, and our lawyering faculty are incorporating lessons related to the safe and effective use of artificial intelligence in law practice early on for our students. And then, of course, students and faculty in our Edward P. Justice, Swire Justice Center are also learning how to use new technologies to improve services to their clients every day. We're even, and this is very exciting, we're even hosting our first interdisciplinary hackathon this Sunday at the law school with faculty and students from the law school working side by side with faculty and students from the University at Albany as they learn together how to use AI-based tools to solve legal practice problems. And Dean Brescia is the brains and the work behind this, so thank you for that. Now, all in, we have a kind of a growing and deepening commitment across the law school and beyond to train the next generation of lawyers and how to prepare themselves for the changes that are afoot in society and the profession. And it's fitting that our chair in law and technology is here to help give us a peek into that future. But now, just quickly, before I turn the floor over to Dean Brescia to talk about his new book, I do want to mention that we hope and envision this wonderful book talk is the first in a series that we'll have over the semester, where we'll also hear a little bit more about books that have been published by Professor Jonathan Rosenblum, Professor Jennifer Martin, and perhaps others, because as many of you know, our scholars have, deep and important voices, and we want to share them with you. So stay tuned for more on that. Now, we are very lucky to have Ray, Dean Brescia, as part of the Albany Law School faculty, and I'm excited to hear what he has to share tonight. So please join me in welcoming Ray, and Ray, over to you.
Thank you so much, President Carline. I really appreciate that kind and gracious introduction, which really reflects you, kind and gracious as always. And I want to applaud you. It was recently announced that we've got you for at least another 5 years. So everyone, congratulations to Dean Carline for committing to us because we are so grateful to have you at the helm in these rocky and stormy times, right? And one of the things that is scaring everybody, I think, in the profession is AI. Before I get into that and give a frame for the book, I really want to thank a couple of people who are really important to having this event tonight and who support the work of everybody and the faculty and staff. And that's you see her name. She's off camera. Sachiko Sachi Vines at the in our Department of Institutional Advancement, who leaves no stone unturned, makes everything just run perfectly, even as the storm came in, and we had a great event in New York City last week, and again we're here tonight. So thank you to Sachi for all of your hard work, and the folks in our communications department, Lauren and Tom, who are here. Thank you for all your work in supporting us throughout the institution. And it's great. I'm seeing in our small but spirited group here tonight. It's a bit of this is your life. I've got Jay Sullivan, a former Skadden fellow from way back, all the way to former students, current faculty members. So thank you all for indulging me this evening and listening to some of my thoughts on the future of the profession. I like to take on big challenges. Whether my reach exceeds my grasp, I don't know, but I never hesitate to try. And so this book, as the President Carline pointed out, Lawyer 3.0, a guide to next wave lawyering. In order to tell you what the book is about, I really have to start with the title and why we are at what I think Lawyer 3.0. In order to do that, I've got to tell you what Lawyer 2.0 was, right? So the book, the framework for the book is the sense that, like 130 or so years ago, when we created the modern and I would argue still contemporary legal profession, right? In the late 1890s, early 1900s, we created at the time many of the institutions that we think of when we think of the American legal profession today. It's our law schools, our bar associations, our codes of ethics, law firms, bar exams, for the most part, these may have existed before the turn of the 19th to the 20th century. In fact, in our 175th year, Albany Law School was one of the law schools then in existence at the time, of course. And other, whether it was Harvard or University of Tennessee, University of Virginia, schools had either a law department or a law school within the larger university, but only a small fraction of lawyers at the time went to law school and practiced law after getting a formal law degree. So at the turn of the 19th to the 20th century, a number of things were happening that led the profession to create these institutions. And many of them simply, either if they did exist, they were shadows of their present selves, right? You think of the law firms at the end of the 19th century. Law firms, like Couder Brothers. Well, Couder Brothers was a bunch of brothers practicing together, right? And we see, many, the cravat, the cravat model, which many law firms adopt now. Cravat was, a small number of lawyers working together in New York, right? So in many instances in the later part of the 19th century, law firms were kind of like a couple of lawyers sharing space, like as if there were in a WeWork today, right? There were a loose affiliation, two or three lawyers at most. But then with the change in the economy, the industrialization, urbanization, increased immigration, all of this started to create the need for a different kind of law practice. And technology not only impacted what lawyers did, i.e., what they worked on. If you're representing a railroad company or a company refining petroleum, technology was, what you were working on, right? And it impacted how you worked as well, because the companies, they think about the vertical corporations, they needed integrated law firms that could do a lot of things for them. So technology was impacting the what lawyers practiced, but also it impacted the how. And we start to see new technologies at the time, simple technologies we might think of today, like the telephone and the typewriter and the ability to reproduce, to mass reproduce judicial opinions, actually had a big impact on the way lawyers practiced, right? And you even have law firms. I mentioned Cravath. When a telephone was brought into Cravath, they sort of worked in an open plan. There was a telephone booth in the middle of the office, and one of the name partners said, "Get that thing out of here." What client would want to get a telephone call from a client? And with typewriters, what client would want to get a telephone call from their lawyer? What client would want to get a typewritten note from their lawyer? Has to be handwritten, right? So at first there was resistance to these technologies, but then the technologies get adopted. You had the old school lawyers, if you would, who could go into court and argue from general principles. They were up against lawyers who actually read judicial opinions that had been mass produced and distributed. So the way that lawyers practice changed. Another significant change that happened. So up to this point, there was the process of becoming a lawyer, was, at least for the first part of the 19th century, was the apprentice model. That had largely gone the way of the woolly mammoth. at the end of the 19th century, and access to the legal profession was quite easy. There was, limited methods where a limited bar exam. Many states had a diploma privilege. So if you got a diploma from a certified law school in that state, i.e., a law school that the equivalent of the State Board of Ed had authorized and had given a charter. If you got a degree from that law school, then you could practice law. Now, another piece of the access to the profession was that up until that point, pretty much the only lawyers practicing were men, white men, and the native born children of native born parents. So, immigration until the late 19th century, immigrant lawyers had not quite penetrated the profession, but then they start to, and we start to see law schools crop up, like the Portia Law School in Massachusetts, in Boston, that was designed to train working women on evenings and weekends. We see law schools start to train African American candidates for the bar. Immigrants are coming to these, evening and weekend law schools at striking numbers. New immigrants from Southern and Eastern Europe, Jewish immigrants, Italian immigrants, Catholic immigrants, and this is very different for the bar. So the bar leads in the profession, whether it's the ABA or in 1900 the formation of the American Association of Law Schools, the AALS. They begin to advocate for uh, codes of conduct, bar exams, restrictions on law practice, much more onerous requirements for law school. So we can't think about our history and not recognize that at the turn of the 19th to the 20th century, we created a new legal profession where it was fairly easy to get into, at least in the second half of the 19th century, if you were white and male. Um, and then when the barriers to entry began to lower demographically, the elites said, "Well, we can't have that. We've got to have stricter controls on access to the profession. We've got to impose educational requirements," knowing that it would make it difficult for low-income people, people of color, people from religious minorities would have a harder time getting into the profession. So we create all these institutions, and some of them have very valuable purposes, for consumer protection purposes, to make sure lawyers had adequate training for the new and complex economy and the development of new rights that are emerging. But they also certainly have a darker side. Now, fast forward, and you don't have to fast forward that much because, frankly, a lawyer in 1930 looking at the legal profession of, say, 2020, apart from the demographic change, the legal profession looked very similar in how it operated, what it worked, how it worked, what it worked on. And now we're at a point where I think we're seeing similar changes afoot, and the most significant one being technology, is about to, I think, make a significant an impact on the legal profession that those forces, including technology, had in the turn of the 19th to the 20th century. All right. So now I was a law student in the late 80s. And that was when we saw, new forms of word processing, new technologies, the personal computer, online, although we didn't call it that, electronic research, right? Where I went to law school, we had 10 Westlaw terminals that were in the basement of the library. And if you wanted to do research on Westlaw, you had to go downstairs to the basement and see if you could get the computer with I think we had CD-ROMs that had Westlaw on them. And then I entered practice in 1992, in the fall of 1992, when my office, Legal Aid, got we had desktop computers on a mainframe, and many of my colleagues still wrote out everything that they did longhand. Some of them dictated, but most of them wrote things out longhand. And they would give it to their secretary. They went to the secretarial pool. The secretary would type it up. They would come back and make changes. Right. One of the things that, and this will sort of show you, where I think how technology is going to impact what we do today. One of the things that I would hear, so I was doing eviction defense work. And so one of the things that I would hear all the time is my colleagues walking down the hallway, going door to door, asking the rest of us, hey, has anyone done an answer with a rent overcharge claim in it? Hey, has anyone done an answer with a statute of limitations claim, defense in it? Hey, has anyone done an answer with a latches defense in it? And people say, oh yeah, that was the Jones case. Let me pull that file out of my filing cabinet. Here's the answer. Here, take the file. You can have your secretary sort of retype that section of and this sort of pastiche of answers, these Frankenstein monsters of answers people would put together all the time. And I said, folks, we could create a single answer, a kitchen sink answer that had every possible defense, counterclaim, objection, and point of law, everything that we could possibly dream of that we ever put in an answer. We could put in a single answer, and you could fill out a form for your secretary, or you could even do it yourself, is call up that document on your computer and just cross out the things you don't want. It's like, ooh, we can do that? It's like, yes, we can do that. And that much as I loved having my colleagues walk down the hall every day asking me whether I had certain defenses, it made our work a lot more efficient. And I think that you could fast forward again to today, and we're seeing not just things like electronic research making work a lot easier and a lot faster, but we're starting to see technology creep into how lawyers deliver services. But we're also seeing that people are, no question, turning to some of these publicly available products like ChatGPT and others to get legal answers. And they're doing that because the cost of legal services are way too high for too many people to afford. And at present, 92% of low-income people and roughly 50% of middle-income people face their legal problems without adequate representation. Some of it, there are lots of reasons for that. Significant one is certainly a lack of resources to pay for a lawyer, but there are many other reasons. And the researcher, Rebecca Becky Sandifer, has done amazing work on this, which I cite in the book, about the reasons why people don't access a lawyer. And it's not just that they can't afford one. It might be that they don't understand they have a legal problem. They don't think it's a problem that a lawyer can solve. They don't know a lawyer who they can contact. They think that it might be something like fate or God's will that they have this problem, and they might try to resolve it. They might turn to a trusted community member, a family member to try to resolve it, or they might just not do anything about it if they even know they have a problem in the first place. So, the commentator Richard Susskind calls this idea that there are quite literally tens of millions, if not hundreds of millions of Americans alone who don't have adequate legal services to address their legal problems, the latent legal market. That there is a significant percentage of the American population that faces their legal problem without a lawyer, whether they know it or not. And whether no they have a legal problem, they know whether or not they have a lawyer, hopefully. So in this moment, right, when you've got this sort of confluence of forces, right? Expensive legal services, which is, understandable given the cost of things like a legal education and the time and effort it takes to get a law degree and then to maintain a practice, right? Legal services are expensive, but there are reasons for that. There are reasons for that. This latent legal market, but also the technology that could deliver some type of services to people, and people will turn to it whether they will truly benefit from it or not. So this confluence of forces, I think, means that the legal profession has a responsibility to get out ahead of these changes, to understand what technology is good for and what it is not good for, to train the technology as well as the general public and those who might look to utilize these tools, where they might fall short, where they might be sufficient, and where they might be adequate to meet people's legal needs. And I sort of use in the frame for the book the idea that, borrowing from the late Harvard Business School professor Clayton Christensen, the idea of the job to be done. So he has a great work where he lays out, it's called Competing Against Luck is the book. He lays out what he calls the job to be done framework. What is it that a consumer needs? And in many instances, consumers might get ultimately to the point where they say, well, what I really need is a lawyer. But what they get there by understanding that they have a legal problem and understanding that they want the problem resolved, right? And so there's an educational component to that for people to understand they have a legal problem, an educational component to that to people to understand that a lawyer can help solve their problems. But there also is an access problem, is that we have to be able to provide services that address the person's legal problem in an effective and efficient way. But it requires lawyers to take a step back and understand, right, that the point of the legal system is not to provide jobs to lawyers. It is to help people solve their legal problems, right? And so we have, I think, as fiduciaries, not only of our clients' interests, but fiduciaries of the legal system, to ensure that access to justice is a cornerstone of that system. And if it means that we help to build the systems that provide better and more accessible and efficient services to people, I think we have to do it. And I do think that there's a market and a hunger out there that won't necessarily displace lawyers when there's somebody who has the resources to pay them. There might be some loss in the middle, but I think that there's a market opportunity for lawyers to serve that middle and to provide effective, efficient services at scale. But we also need to understand that job to be done, right? And so what I try to develop in the book are, how do we assess a client's job to be done to determine when traditional full service services from lawyers are necessary for that consumer to get their job to be done, and when are there other types of services, and they still can be provided by lawyers, but in a more efficient, more cost-effective way that can nevertheless help people actually solve their legal problems. So it requires us to understand what are the values that we are supposed to bring, to the legal system as lawyers, and what are our functions? And so I go in the book to try to understand, what are those values, right? The values are, that we have an adversarial system, right? That requires advocates or at least information and guidance on both sides of our disputes. And it could be a dispute or a negotiation, litigation or the sale of a home or something like that. We have a system where we want lawyers to be zealous advocates to make sure that clients' interests are protected, right? So we have an adversarial system. We believe that adversarial system requires access to justice. It is a system that is designed to protect democracy. It is a product of democratic institutions, and it is supposed to be where we honor and advance the rule of law. So all of those are the values that the profession is supposed to bring to our legal system and to legal problems. But then we also have several functions, right? And sometimes those functions are purely instrumental, right? Get the client's application filed for citizenship or whatever it is, right? So there's an instrumental value. There is an affective value, right? That which is, the emotions of a situation. And some clients need more handholding than others, if you would. Some situations are more emotionally fraught than others. The something where the instrumental value is to finalize the sale of a home with a mortgage attached to it. Well, from the lawyer's perspective, this is what they do. They do residential real estate closings. This is so easy. A paralegal does a lot of the work, right? In the background, filling out the forms, making sure all the forms, the client comes and signs everything. But that is an incredibly emotionally fraught situation for most clients. Now, if it's your fourth home and you really want that ski house in Aspen, okay, great. But if this is your first home, you've been saving for it for years, right? Maybe you got a little money from family, but this is going to be your nest egg. This is going to help you build wealth. Maybe so you're the first in your family to be a homeowner. This is a serious, serious situation where the instrumental, the expertise that the lawyer brings is relatively low in a simple, straightforward, qualifying mortgage setting, right? But the affective element is super high. And then finally, the political function that the lawyer plays, and I'm small p political, how we interact with each other, how we interact with the state, all that. Those are those functions. We have instrumental, affective, and political functions that we play in every setting, right? In some instances, right, there may be situations where a technological solution may be more than adequate to satisfy the client's job to be done. And in fact, if it's built right, it might eliminate some of the errors that lawyers sometimes make along the way, right? So you could see, so there's a great program if people are interested in it called Citizenship Works. It is a website created by the organization Pro Bono Net, and it helps people apply for citizenship. And it's, just think TurboTax. It's TurboTax for citizenship applications. And throughout the process, right, person who there's initial screening done online. Is the person potentially eligible? Are there any major red flags? You know, Throughout the process, if something comes up that makes it apparent that this is not a simple and straightforward application, then the system says, do not pass go, do not collect $200. Your case is too complex. You really need a lawyer to help you through it, right? You may have had some kind of misdemeanor conviction or something like that from 20 years earlier that could make it more complicated, and you're not appropriate for this service, right? But for the overwhelming majority of people who use the service, they are eligible. They can go through it very, very quickly. The only fees they have to pay are for the filing fees that they have. Now, are there some law offices that are losing clients because of that? Yes, it is possible, right? It's even likely. But these are very relatively straightforward cases. And the success rate using this tool is extremely high. And again, I go back to my point before. The point of the legal system is not to provide jobs for lawyers. It is to help people get their job to be done. And so and I'll wrap up very soon because I really would like a conversation. May not seem that way, but I do. So this citizenship works. It really is one of the things I get into in the book, and I've got other sort of ideas about how we shepherd in this Lawyer 3.0. But I think one of the things I'll just stress this, which comes, really the citizenship work example really puts in high relief, one of the solutions that I see, and one of the trajectories for the legal profession. Historically, what we say we do when practicing law is we sit down with a client, and they are, the most important person in the world the moment they're in our office. Their case is unique. It's very complex. Yes, this is we're gonna do what we can. We're gonna protect your rights. And we create what again, to turn to Richard Susskind, says, a bespoke model, a specific model to fit this client. That's how we're going to intervene. That's how we're going to serve this client. In reality, what we often do after that client, while the client's there, we're thinking through it, oh, this is just like the Jones case, it's just like the Smith case. I've got, kind of like what I was saying before about my office, right? Who's got statute of limitations defense? Who's got a rent? You're going through your head, when did I take on a case like this before? I'll start from those pleadings. I have to file a complaint, I have to file an answer, whatever it is. I'm going to do a real estate transaction. I'm going to write a will. When did I do something kind of like this, right? This is a lot like, lawyers operate in a way that is very similar to the way the Netflix algorithm works. So the Netflix algorithm looks at and a lot of, sort of algorithms work this way. They don't say, okay, Ray, you and your spouse really seem to like Nordic noir detective stories, right? So we're going to recommend the next Nordic noir domestic detective story, right? No, they say you and your spouse watched these three shows, right? Those are the last three shows you watched. Who else watched those last three shows? Well, the people who watched those last three shows, this is the next show they watch, so we're going to push that show to you. Lawyers do that every day, right? They look at their client and they say, you know what? This is like these three cases I handled before. I'm going to start pulling things together. What I think we need to do more of is what Citizenship Works does. Instead of triaging clients and saying, okay, we're going to figure out what services this client needs, and then pull together a response, what we need to be doing more of is having relatively straightforward, out of the box solutions and triaging the solution to say, okay, is this client appropriate for this solution, right? Does this client fit this solution that we've developed, an out of the box, much less expensive solution to the client's problem, right? It's got to be effective, it's got to be adequate, it's got to be competent, all of that, right? But if we start building these tools like Citizenship Works that provides, commoditized services that assesses clients for whether they're appropriate for the services and not what we do a lot of, which is determine what services are appropriate for the client. And as with citizenship works, a lot of people are perfectly appropriate to use that tool, and their success rate shows it. But if you're not appropriate for the tool, it sort of says, it tells you, no, you should consult, a lawyer. So now, there are, serious unauthorized practice of law questions that are raised by these sorts of solutions, and absolutely happy to get into them. In New York State, we have this line where, the Dacey case sort of establishes it, where services that are tailored to somebody are considered the practice of law. General guidance that is not tailored to a specific client's or customer's needs are not the practice of law. And I think we can do more on the not practice of law side, and help to serve more people in a more efficient, more effective way. And I lay out some of the other ways that we can do that in the book. Now, I've already talked for way too long, so I'm really eager to hear from folks, and answer questions, feedback that you have. How do we want to do this, Sachi? Should people raise their hands if they want to ask a question? Or
I think
Lauren?
that's great.
Okay.
I can get us started while folks are thinking,
Yes,
if that's
please
okay.
do. Yeah,
So
yeah.
this
And
is
we don't have to turn on your microphone or anything.
So this is fascinating as always. It's interesting because I learn more every time you talk. But the more you talk about the kind of the Lawyer 3.0 and the world we're living in, I think about it as this kind of interesting intersection of the democratization of information coupled with efficiency. And historically, we haven't always put those two things together. And many times, access to information was not efficient. And so, we're living in a world where perhaps those two things can coexist. And in many ways, the lawyer is the human in the loop that can link those. And so I'm wondering if you see it in that way, but then I'm also wondering if you can speak a little bit more about what role you think of regulation playing in this context, kind of at the local and federal level too, because I was one of the benefits of being virtual is I could also look at the Citizenship Works website while you were talking, and it's incredible, but it also is the kind of thing where you could see really bad versions of that, and people would have a really hard time differentiating because of that initial kind of lack of information piece, or and so maybe blending those two questions and then just turning the floor back to you.
Well, thank you. I think absolutely that there is, the democratization of information. There's the Free Law Project. You can go on the Cornell Library website and get virtually any law. Harvard has digitized millions of judicial opinions for the last 200 years. There are new products coming online virtually every day. Describe is a group that I talk about in the book that uses generative AI to summarize cases. It's not a substitute for research, but it helps people get a sense of what cases might be relevant to their situation. So information is absolutely becoming more and more available, and I think because of that, I'm sure in the medical field, every physician, the sentence they fear the most is, hey doc, I was looking at WebMD last night, and oh, it's Legionnaire's disease again. I'm sure of it, right? Lawyers now are competing, if you would, with ChatGPT and other resources where this information that is available is, sometimes it's accurate, sometimes it's not, and it's helpful when I would think when a client says, hey, have you thought about this? Have you thought about that? Here's some things I found on using generative AI. Okay, maybe you hadn't thought of something as the lawyer. Maybe you had, and it takes a little time to explain why what the person presented, what your client presented to you, isn't helpful. But it might be a new angle on something, or it might have saved the lawyer some time, we also have certainly, I mean, I have gotten through almost 45 minutes without using the word hallucination, but virtually every day there is a decision that comes down where a lawyer or a pro se litigant used hallucinated cases. And we've got some of our students are doing some great research in this area. So there is absolutely, an information overload and an information, there are errors in the information that is produced. And that is, why, again, I think the legal profession has to get ahead of this stuff, not to suppress it, but to make sure people understand the risks, and are and as the profession is having a hand in helping to build the tools that will improve these mechanisms, these whatever the search engines, and their outputs, but to educate people about the risks. Now, judges have done some very interesting things in issuing standing orders around generative AI, from just warning people about its use, to banning its use, to even requiring adversaries to point out in courtrooms where its use is banned when they suspect that their adversary used generative AI. So we are very much. People sort of like to throw this idea around. Today generative AI is as bad as it's going to be. It's only going to get better. Okay, that's great. We can only hope that's true. But I think we have to educate people about the risks, but also, right, not because we want to preserve our monopoly, but because we want people we want to make sure people aren't harmed by any of these tools. So I do think, we can have a head in the sand approach and just try to regulate and play whack-a-mole, but I don't think that that's going to work. I much prefer that we can use some regulation. Again, courts are issuing these standing orders warning parties, litigants, lawyers, pro se litigants, about the risks. We have to be out front about those risks, but also to be conscious of the benefits, right? So we have and it's a very long-winded answer, and I apologize. We have, adopted in comment 8 to rule 1.1 around competence that lawyers have to be, keep abreast of changes in the law and the ways that technology, its risks and its benefits. And I think that that shouldn't just be a phrase in a comment in a rule. I think we should have more rigorous rules around its use, but also that we have a responsibility to use it to lower costs and to expand access to justice. Do I have to cold call somebody? I'm not above that, but I won't do it here. I won't even call Marianne, one of my former students and research assistants. Um, Jay, my brother in Skadden Fellows, felt in the Skadden Fellowship. We have to let him speak, right? Allowed to talk. Yes, come on board, Jay. It looks like you should be able to speak, but I can't hear you. All right, we'll come back to Jay. Let's Marianne, come on board. Unmute yourself.
Good evening, Professor Brescia.
Hello, Professor Krista. How are you?
I'm great. Fascinating stuff. My brain is all over the place. I was actually going to try to write, just so you know, I was going to try to write in the chat, but the chat is disabled, so you can't
Okay.
post any questions there. One of the things I've been thinking about a lot is with the advancement of Gen AI.
Well, Marianne, tell everyone where you work.
Oh, I work at the Appellate Division, Fourth Department. I'm a principal court attorney here in Rochester. And I am a former student and I was disciple of Professor Brescia. So all things I do are, I hearken back to him. But the thing, I've been doing some development of technology stuff myself with the court system. And one of the things that I find interesting, and I don't know if you have any comments on, is how many lawyers are involved in the process of actually building the thing from the ground up. I don't know many developers, software developers who are lawyers. And so in some instances, it appears that the process itself involves many, many legal questions. So that was a general comment slash sort of question. And the other thing that I was struck by is your initial comment about lawyers aren't, and it's not lawyers not to get jobs, lawyers to solve legal problems. And given all the givens in this world, I'm wondering how you are distinguishing what the definition of legal problems, how broad and how narrow and all of those things. And at that, I'm just going to stop because otherwise I'll just keep going. So I
Well, thank
apologize.
no, no, no. Thank you for the questions. I do think that there is a lot of sort of disruption, or at least people profess their belief in disruption for the sake of disruption. And we've had companies like LegalZoom come on board, and there are many, new companies. Interestingly, I think very few of them are what we call B2C. LegalZoom is one, so business to consumer. A lot of legal tech now is B2B, business to business, where people, companies are trying to sell their tech to law firms and law offices, in-house counsel offices, government attorneys. And so I think that some of the people involved in these initiatives are lawyers. Many of them are not. I do think that the getting the tech right requires technologists understanding the ethics and the values requires lawyers. So I do think, and that's, President Carlin talked about our hackathon this weekend. We're bringing folks, faculty and students from UAlbany into this hackathon for them to understand, legal processes, the ethical values that lawyers operate under, and to work with our students and faculty to try to understand how to harness some of these new technologies. So I do think it's interdisciplinary. It needs that, whether you say human in the loop or lawyer in the loop. I think both. I think a lawyer can be both human and a lawyer. But I do think that there needs to be more interdisciplinary work. I certainly go into that in the book. As for the second issue, I think one element of lawyering is that we need to help people, is the marketing aspect of this, which is to help people understand when they have a problem that is emerging that could be a legal problem, particularly if they don't do anything to address it, right? And so I do think that we can spot a a legal problem. Somebody is sued, somebody is charged with something. That's an easy legal problem to identify. But there also can be other problems that if there was some intervention, there may not be legal problems, larger legal problems down the line that you need a lawyer to unwind. So I'll use it as example, and I do talk a little bit about this in the book. But consumer debt problems, there can be you can have somebody who is otherwise judgment proof. They
Mhm.
receive disability or they're senior citizen that doesn't have any assets, but they get sued, or they get a dunning letter. They get a letter from a lawyer's letter saying, that there's a debt that's outstanding, medical debt or whatever it is, but the person is judgment proof. And generally speaking, and there's pretty good federal law on this, with respect to some types of judgment proof status, that it's a violation of federal law. It's an unfair debt collection practice in many states. If the person is judgment proof, so if the individual has the knowledge that they are judgment proof, they can, send a letter, and the letter can cite the relevant statutes and protections, and hopefully that ends the problem, right? They may not know, they may just ignore the letters. They get letters from collection agencies, maybe routinely. Sometimes they turn into lawsuits, sometimes they don't. But if they are aware of their legal rights and they can alert the party seeking payment on the debt that the individual is judgment proof, then maybe no lawsuit ever happens. If the lawsuit does go forward, and the party gets a judgment, even though the individual is judgment proof, it takes a lot of work to unwind that, right? So how it is way too often that individuals, low income people, middle income people, who are sued in whether it's small claims court or in civil court for relatively small amounts, relatively small, maybe $5,000 to $10,000, the first time they really learn about the case is when their bank account is frozen, right?
Yeah.
Because they've never been sued, or they've never been served, right? They get a default judgment entered against them, and then their bank account is frozen. They can't pay their rent, they can't get their medications, so they have to go to court to try to unwind that order, that order that freezes their bank accounts. So people who, with some early intervention, that can prevent bigger problems from going down. And I do think that it's a bit of a marketing issue, that we have a responsibility to make sure people are aware when they're legal, when they have a problem that might have a legal solution to it. I hope that answered your question again in a very long-winded way. Questions? And
Thank
I
you
don't
so
know if
much.
Jay is still with us, if he's able to speak or not. I'm sorry that we weren't able to get you the first time around. All right, maybe Jay has left us. Any other questions? Well, we have gone a full hour, and Sachi is going to work with me. I've got my signing pen. I'm all ready for to sign books if people asked me to sign them. So, Mike,
Mike
yeah,
has a question.
yeah, fire away, Mike.
Right. Well, we have a cases now with AI, et cetera, that people's videos are being presented of people who are not that person. And that maybe that, I don't know if the legal profession has faced this, but it will be a problem. Even a th person like authority, like um, a professor, could be speaking something about the law, or somebody speaking matter, which is not true, but it appears to be. So one has to be very skeptical of what is appearing today. How does one, well, one has to be very careful the sources, right? And
Well, two things. So that was a great point. Well, I thought you were going a different direction, which I'm going to get to in a second. But absolutely, deep fakes and disinformation, people getting information that is not accurate about their rights is very risky. Again, and this happens every day. Thousands of people are absolutely asking ChatGPT for legal guidance, and it's often wrong, right? So that is one of the things we need to get out in front of. The other thing, what I thought you were going to say is that there was a recent case where someone used AI to give a victim statement after the victim had died, so
Hmm.
that they used AI to say what the victim would have said in using their image and likeness, which I believe the court did not allow that, and I think sort of that doesn't satisfy the obligations of of evidence, right? It's not a fair and accurate portrayal depiction of the evidence. There was also a case recently where an attorney, or no, excuse me, a pro se litigant wanted to give their oral argument. I believe it was in an appellate court, wanted to give their oral argument using an avatar that was much younger than the pro se litigant, and the court did not allow that either. So yeah, no, I think that we're going to see all sorts of these things. Now, I do think that there are, and Albany Law students are building some of these tools now, where you can give effective information to people who about their legal rights, right? The information is accurate, and it's just in time, just enough information to help them. That is a positive. But certainly, active disinformation, or the disinfor or incorrect information that comes out of some of these generative AI tools, we absolutely have to be concerned about and have to police. So thanks. That's a great point.
Thank you.
All right. Why don't we stop it there? Thank you, everyone, for attending. I'm glad that we could do this and keep everybody safe at the same time. You will get in the mail soon enough, if you ask for it, a copy signed of the book. Thank you to all of you for attending, to those of you who purchased the book, and thank you again to the team at the law school who helped make this event possible, even in the midst of a winter storm. So thank you, Sachi and Lauren and Tom. Thank you, President Carlin, for the kind words of introduction and serving as our host. So I hope to see you all soon, and do keep an eye out for those events we're going to have later in the semester. Hopefully, when the weather's a little better and we can really not worry about the ability to celebrate in person. So thank you, everybody. Have a good and safe evening, and I hope to see you all IRL, as we say. Good night, everybody.